Good afternoon. I think that we will begin. Welcome to Marquette University Law School's annual Hallows Lecture. My name is Joseph Kearney, and it's a great privilege for me as Dean of the Law School to introduce both the lecture and the speaker. This lecture is an annual occasion to recall a great Marquetter. E. Harold Hallows graduated from this university with a degree in philosophy in 1926. He left Milwaukee for law school, I am sorry to say, though glad, as you shall see, that he attended and graduated from the University of Chicago Law School in 1930. A native of Fond du Lac, Hallows returned to Milwaukee to practice law. For a most unusual matter, he was immediately appointed to the part-time faculty at Marquette Law School. He served with distinction, even in the midst of his busy law practice and substantial engagement in civic affairs until 1958. A generation of students took courses such as Equity and Equity II from Professor Hallows. He became a Justice of the Wisconsin Supreme Court in 1958, serving until 1974, the last 6 of those years as Chief Justice. His tenure on the court overlapped with that of 2 of his former Marquette Law School students, Justices Leo Hanley and Robert Hanson. This decade and a half was a dynamic time in the law, and Chief Justice Hallows, insofar as Wisconsin was concerned, was at the center of it. Each year, for more than 2 decades now, the law school holds this lecture in his memory. We invite a great judge to be with us. Today, it is our distinct honor to welcome the Honorable Lee Rosenthal, Chief Judge of the U.S. District Court for the Southern District of Texas. This encompasses one of the nation's largest cities, Houston, and much else as well. Judge Rosenthal has served on that court since 1992, when she left the private practice and a partnership at Baker & Botts. She is an acclaimed trial judge and student and teacher of the law. Some evidence of that includes her appointment by Chief Justice William Rehnquist, first as a member and then as chair of the Judicial Conference's Advisory Committee on the Federal Rules of Civil Procedure, as well as her subsequent appointment by Chief Justice John Roberts to the Judicial Conference's Committee on Rules of Practice and Procedure. So it is her professional work that recommends her, as it were. At the same time, that she is, as E. Harold Hallows was, a graduate of the University of Chicago Law School, seems to me a nice coincidence, as does the fact that she, like Hallows, received her undergraduate degree in philosophy, alas, from the University of Chicago, not Marquette like Hallows. She does us a great honor by joining us today. Won't you please join me in welcoming the Honorable Lee Rosenthal.
Thank you all very much for being here. It is a great pleasure for me to be here. It's my first time to Milwaukee. It's my first time to Marquette. But it is a particular pleasure to be in a law school that is committed to the Jesuit ideals of education, including the Latin words, which I will not attempt to pronounce, meaning care of the entire person. And that is in keeping with what I want to talk about. Now, having said that, I was very intimidated when I looked at the roster of prior Hallows lecturers. It is a who's who of who matters in the judiciary. And I am moved and honored by the presence of so many distinguished judges and lawyers. Thank you all for being here today. It means a great deal. And I did not want to be in the position of the woman who left a dinner party apologizing for having dominated the conversation. Her host, like Dean Kearney, a renowned law school dean, reassured her, "Don't worry, you didn't say anything." What I do want to talk about goes back a long way, 150 years. It's been almost that long since the most famous observations about what I do want to talk about, what it means to have ambition and aspiration to live greatly in the law. I don't know about you, but I get goosebumps when I say those words, to live greatly in the law. It was Justice Oliver Wendell Holmes who wrote these words and thought about this in the 1880s, and who provokes a discussion that I think has great relevance and importance today, and to all of us at the various stages and phases of our lives in the law. Some of you are law students, some are practitioners, some law teachers, and some law deciders. It's hard to overstate how much each of these areas has changed since the 1880s, but the question is still fresh. And of course, Justice Holmes approached this question in a context far different than any of us can imagine experiencing. He was a soldier in the Civil War. He studied law and philosophy and religion and history. He was a scholar of renown. He was a lawyer of fame, and he was, of course, a brilliant jurist. But he still called this the main question, the question that shaped his own life. And here is a broader quote: "How can the laborious study of a dry and technical system, the greedy watch for clients and practice of shopkeepers' arts, the mannerless conflicts over often sordid interests, make out a life?" It's a good question. Is it ambition that provides the answer, or is there some other driver that provides the best direction for a good, a satisfying, even a great life in the law? So I'm going to look at the difference between what I'll call ambition and aspiration in this context, and how they might play out differently, but with common aspects for students, practitioners, professors, and judges. And I'm going to compare what it means to see the aspirational side of judges and the ambitious side of judges, because I think all judges have some of both. And the same for law professors and law students and lawyers, and ask how the question looks in 2019, and if we can come up with a modern recipe. So how am I defining these terms to start? Like any good judge or law professor, you got to have a footnote that explains how you define the terms. Ambition. As I think Holmes used the term, and it matches my understanding, it really is the drive for external validation. For law students, ambition can be in the form of, and often is, looking for the approval of parents. For professors, in the form of good grades, law review, moot court, research assistantship, internships, clerkships, jobs. External validations. For lawyers, beginning practice, it's to get the approval of more senior lawyers, and then partners, clients, anybody with power to promote and reward. For academics, similarly, it's to win the approval of those who are hiring, making decisions on where to publish, whether to promote, whether to grant tenure, and perhaps to confer that oh so coveted chair, not to mention the parking place. For judges, it can be the desire for appointment or confirmation or election, then high rankings in bar polls, being cited and pleas affirmed, re-election or promotion. Ambition for everybody but judges can include the desire to make money, to accumulate wealth, even beyond financial security. It can include the desire to have a secure reputation for excellence and influence in the profession. None of this is bad. And we all have ambition. We all need it. It got us where we are. It got Dean Kearney dean. It got me judge. But not by itself, I don't think. Is ambition enough? Holmes clearly thought not. He recognized the economic realities of being a lawyer, and he did not denigrate what he called the, quote, wish to make a living and to succeed. Few do, few should. He recognized that we all want these things, but he also saw that that kind of success was not enough. He said, and I quote, happiness cannot be won simply by being counsel for great corporations and having an income of $50,000. Yeah, I told you times had changed. And so he went on, an intellect great enough to win the prize needs other food besides success. I think he's right. There is something more to the study and the practice of law that makes it satisfying in a way that feels to approach greatness. But what is it? What is this something more that lets us say that we can live greatly in the law as elsewhere? So Holmes gave us a pretty general idea, but I don't think he's wrong. Inadequately summarized, it seems to amount to striving to see the broader principles, the ideas in the quotidian facts and problems of specific matters, disputes, or cases. The key is to see the general beyond the particular, to search for what he called the remoter and more general aspects of the law. Holmes thought that it was this enterprise that allows the law student, the lawyer, the law professor, and the judge to connect their subject with the universe and catch a hint of the universal law. And to do this, he recognized, requires what he called complex and intense intellectual efforts. But it is those very efforts and the insights that they can bring that provide the hope of personal satisfaction, fulfillment, and the sense of approaching greatness. Holmes explained that jurisprudence, as I look at it, is simply law in its most generalized part. Every effort to reduce a case to a rule is an effort of jurisprudence. One mark of a great lawyer is that he, and I'm sorry, everybody is a he in his world, sees the application of the broadest rules. And his rhetoric was beyond the soaring. Viewed in this way, the law is as in a magic mirror. We see reflected not only our own lives, but the lives of all men that have ever been. When I think of this magic theme, my eyes dazzle. He does have a way with words. Now, interestingly, he did not prescribe going out to do good as the way to feel good about the law. It wasn't the something more, although he didn't denigrate efforts to improve social justice or the greater good. He found, though in a perhaps cynical way, altruistic and cynically selfish talk about equally unreal. It's an interesting perspective. Pro bono work, as many of you who have been in those fields have found, no less than other work than compensated legal work, has its share of tedium. It has plenty of its stresses, its mannerless conflicts, and it too requires the practice of shopkeepers' arts. So he did not see this as the answer to his question of how to achieve satisfaction and a sense of greatness in living in the law. And I think that the right word for this search for something more is aspiration, as contrasted with ambition. And I credit the philosopher Agnes Callard, and I hope I haven't mispronounced her name, for her articulation of aspiration, which I found helpful. Aspiration, she defines as a distinctive form of purposeful action directed at acquiring new values. And those values are not abstract, but practical and active. Ambition, by contrast, does not seek to acquire a new value or learn what you need to know to do so, even to understand what it is you're trying to do. Ambition tries to acquire what we already value. We already value praise. We already value tenure if we're in the academy. We already value the title of judge. We know what we want. We value approval. We didn't learn about that when we came to law school or thought about what it was we were learning in a broader sense. Ambition helps propel us down the path we already know we want to travel. And it helps us do it well. Callard describes aspiration as a form of agency in which one acts upon oneself to define and create a self with substantively new values by allowing oneself to be guided by the self one is bringing into being. Okay, unpacking that is beyond my pay grade and one reason why I did not become a professional philosopher. But it's a way to think about how you expand yourself, your understanding of the world, your place in it, the way you have chosen to spend your professional life, to spend your intellect, to spend your creativity. It can be an aspiration to expand your understanding or your knowledge or your competences into new areas. For lawyers, it can be an aspiration to be a more effective counselor, a truly gifted teacher, a really wise judge. Not because it will bring material reward, not because it'll bring external praise, but to change yourself, to understand more than you did before, to value what it is you are doing differently than you did before. So a law student who comes to law school seeking the approval of her parents or financial security, she's not an aspirant. Nothing wrong with it, but she is not an aspirant. Those targets are marks of ambition. She comes knowing what she wants, and she goes about getting it. External validations. She doesn't hope that law school is going to teach her the value of those things. She already knows it. She's chasing what she knows. Even a goal like helping people is beyond most law students because they don't know what that means in any concrete sense out in the world. That they do have to learn. The only shape that the law student has with this new value is an educational one. And therein lies the great joy and greatness of law school, learning those values. The experienced lawyer has a much better sense of the values that being a wise counselor can embrace and include. The experienced lawyer can go into a conference room or a courtroom with a client who has difficult choices to make and may think to herself, I want to help this client make a good decision without telling her what to do. And really understand what that would mean for that client, for that problem, for that life. So we aspire by doing things, and we try to see the world when we aspire through others' eyes, through the eyes of the person who may have or may need the value that we are aspiring to acquire. And I don't mean when I use the word aspiration, any kind of hope or wish or some vague long-term goal to bring some result about. Aspiration isn't a vague hope, although it starts that way. It becomes a purposeful self-examination. In order to value something, we have to really engage with it in a way that takes time, intellectual effort, and practice. And given our limits, we have to pick. And picking is not easy. Ambition can help sort priorities, but it can't replace aspiration. So I'm going to take a minute and look at Holmes's own background as context, and also because it's just a great story. And he does have some great quotes. So he's born in 1841. He lives until 2 days short of his 94th birthday. It's a long time, especially in those days. Grew up in an extraordinary home. His father was a doctor, a professor of medicine, an author, and he grew up surrounded by this incredible standard of excellence. He went to private schools, he went to Harvard. He didn't like Harvard. It wasn't the University of Chicago. He thought it was stultifying. He was already a gifted writer, so he wrote, edited a literary magazine, but he almost didn't graduate because he got into trouble with the faculty. He committed the sin of disrespect toward a professor and was publicly admonished. He was mad. So he volunteered for the Civil War. Fortunately, he was not immediately sent to the front. So he decided, fine, I got some extra time, I'll go back to Harvard, I'll pick up the degree. It's the only reason he graduated from college. So he goes back to Harvard, gets his degree, and in October 1861, he sees his first military action. Within the first hour, he's severely wounded. And he takes months to recover. He goes back to the front in September 1862, almost immediately wounded again. And while still recovering, contracts a very common soldier's ailment, dysentery. It almost kills him. Doesn't matter. He goes back in time for the Battle of Chancellorsville in May 1863. You know what's coming. One more time, he gets wounded. This time, when he finally comes back, it's as a staff officer. He had joined originally because of a sense of duty towards the anti-slavery cause. He was committed. But after 3 years, when his enlistment was up, he did not re-enlist. He thought he'd done enough, and he thought, I think, that he had survived one battle too many to continue to tempt fate. So he goes back to Harvard, decides to study law, goes to the law school, and in 1867 gets admitted to the Massachusetts bar. Within a very short time, his peers are writing that Holmes, quote, knows more law than anyone in Boston of our time and works harder at it than anyone else. And for 14 years, he practiced law. He was fully aware of the reality of private practice. He noted in his diary when he was admitted that on his first day as a lawyer, maybe it was a day like this, quote, the rush of clients postponed on account of weather. He did extol the possibility of living greatly in the practice of law, but he was not so happy in the practice. His closest to happiness experiences were those closest to legal scholarship, when he was drafting briefs and arguing them, and in not too much time he becomes much more of a scholar, publishes The Common Law in 1881, which grows out of a series of lectures trying to explain the fundamentals of American law. He is trying to do what he prescribes in short order as the best way to see where the greatness can lie. He questioned the historical underpinnings of much of Anglo-American jurisprudence, and the work contains his most famous quote, "The life of the law has not been logic, it has been experience." He had come to believe that even outdated and seemingly illogical legal doctrines survive because they find new utility, old legal forms adapted to new social conditions. It's a debate that still has currency today. Shortly after he publishes The Common Law, he takes a teaching job at Harvard. One semester later, he is out of there. He resigns to accept an appointment to the Supreme Judicial Court of Massachusetts, which was the state's Supreme Court. His departure from Harvard caused no significant amount of controversy because there were only 5 full-time professors. And an endowment had been raised to fund his professorship, and he left after 1 semester. Can you imagine? Harvard was pissed. But he had quickly concluded that his opportunity for the kind of generalization, the seeing of the fundamentals, moving to the universal from the specific to the animating principle inside the legal academy was too small for what he wanted. I don't know if he was right or not, but he said, and I quote, "The day would soon come when I felt, that the only remaining problems were ones of detail." He was concerned that he couldn't be a great scholar of the law within the academy, and at 40, he didn't think he had enough time to go into another field where he could both make enough money to support himself and achieve the recognition he was ambitious for. So he ends up with dismissive feelings about the academy. And with apologies to this great law school, he says it's a half-life, a withdrawal from the fight in order to utter smart things that cost you nothing except the thinking them from a cloister. But he had ambivalent feelings about practicing law. After 14 years, he said that it may be unhappy, often seems mean, always challenges your power to idealize the brute fact, but it hardens the fiber, and I think it is more likely to make more of a man or woman, that's my addition, of one who turns it to success. Not to engage in the practical struggle for life, he said, is to choose the less manly course. Ambition? It does not sound like aspiration, does it? But what did he think he would be like to be a judge? Would it be more like being in the real world, a practical struggle for life, or more like the academic and the only practice part that he really liked, writing briefs and arguing them? It's really unclear what he aspired to. What is clear is that he loved being on the Massachusetts Supreme Court. He was there for 20 years. He became its Chief Justice. He loved what he called the writing up of cases, and he found the work, and this I find remarkable, easy. But he was never accused of modesty, especially about how he compared to his fellow judges. He said of his colleagues that, quote, "They are apt to be naive, simple-minded men, and they need education in the obvious to learn to transcend their own convictions and to leave room for much that we hold dear to be done away with by the orderly change of law," which, of course, he was in charge of. He was very happy on that court, but this is a man of great ambition. He was famously and obviously ambitious. In 1902, Teddy Roosevelt appoints him to the United States Supreme Court, where he wrote eloquent dissents, often with Louis Brandeis, and often saw them turned into majority opinions, not always, but with what must have been a gratifying degree of success. He is on that court for 30 years, leaves when he's 90, and dies a few years later. And back then, of course, he was considered a liberal in part because he writes opinions endorsing and reinforcing free speech rights, rights of labor to organize, but he was conservative in what we would call personal injury cases. He was a champion of judicial restraint, in today's terms, deference to the judgment of the legislature, and he was on the wrong side by today's standards in some very famous areas. He upheld sterilization of the disabled with enthusiasm. You remember the quote, "3 generations of imbeciles is enough." It's chilling. He opposed women's right to vote, stating that it would take more than the 19th Amendment to convince me that there are no differences between men and women. One wonders what Mrs. Holmes thought about that. But his personal opinions did not often find expression in his judicial writing. He wrote, and I find this perspective fascinating, "I loathed most of the things I decided in favor of." But his reason was hardly self-deprecating. Quote, "If my fellow citizens want to go to hell, I will help them. It's my job." So Holmes clearly embodies both ambition and aspiration. He hungered for external recognition and the validation it would bring. He was hypersensitive to criticism. And for all that he achieved, he never achieved the external recognition he craved. At age 68, he's on the Supreme Court. He is a renowned scholar and thinker. And he says, "I have not had as much recognition as I should like." He extolled the joys of thinking about the law, but his own experience of those joys was apparently diluted by what he saw as the lack of attention to, quote, what one, and I read him, thinks most important. One biographer, G. Edward Wright, has observed that his life's plan was underscored by the fear of powerlessness and the intensity of power seeking. He was ultimately powerless to achieve his ambition of ensuring that others would appreciate the quality of what he did. And that's a big problem with ambition. The big problem with ambition. It's external validation. The goals of professional recognition and eminence, position, advancement, or wealth, they're determined by others. They are beyond our power to control. But Holmes also aspired to understand the fundamentals, to figure out if studying jurisprudence and history and philosophy would show that law was the record of struggles among power blocks or of gradual efforts to improve the rationality of decision-making. He wanted to leave behind the vague and moral-sounding phrases in favor of really what determines, what makes for liability, what should be the basis of finding fault or guilt, what remedies or punishments do and should follow. He was both deeply ambitious and profoundly aspirational. And I think in some ways we all are both. So looking at this combination, I want to first visit the world of judges and talk about how it plays out there. All judges I know have some of both aspiration and ambition in them, but the difference between a judge who bases reasoning or result in particular cases on one or the other is a useful way of examining judging, judicial performance, and the relationship between judicial independence and accountability. There are lots of different ways to be ambitious as a judge. One is the external recognition of being a jurist of distinction or impact, a great jurisprudent. And this part of a judge may count ambition as realized by the number of times I get cited. That's a joyous day. In casebooks or treatises, or by the number and kinds of requests to give speeches. In law school, this was a big day. Another way, of course, is to be ambitious for promotion. and that might be a nomination to an appellate court from a trial court, or the state or federal brass ring, a nomination to the highest court of the relevant land. One type of ambition in a judge is one of my heroes, Judge Carolyn King, an esteemed Fifth Circuit judge, noted in her 27 Hallows Lecture, is to rule with one eye on the obituary and retirement announcements and one eye on judicial promotion lists. And a third way is to seek the satisfaction of one deeply committed to an overarching political, philosophical, or moral set of beliefs. And that judge in that role might get great satisfaction from the opportunity to reach a result that would advance or entrench or expand those beliefs. And I count this as ambition when it strives for the judge's preferred outcome, even if the law or the facts or both don't justify it. I count it as a form of aspiration, perhaps serendipitous, when the facts and the law and the context converge with the judge's preferred outcome. And that preference is based on a sincerely held belief that it and it alone is the right outcome in the larger and more fundamental framework. So let me give you an example. Ambition can be, by the way, on all ends of the political spectrum. It is not more on the left or the right. It's no accident that some of these cases involve difficult and sensitive issues: abortion, sexual orientation, extent of civil and constitutional protections. And please be clear that when I talk about some of these cases, I'm not commenting on the merits, but only on the opinions, rhetoric, and approaches to look at the roles of aspiration and ambition. Now, one example comes from a case that is in an area very controversial and sensitive. It's called the style is Whole Women's Health versus Smith, Fifth Circuit, 2018. Pretty new case. Texas had enacted new regulations for disposing of fetal remains to require third-party vendors to bury or scatter the ashes of embryonic or fetal tissue. Several Texas licensed abortion providers challenged the regulations under 1983, seeking an injunction on the ground that the required method was so expensive as to unduly burden the rights of women seeking abortions. The case was very high profile, as you can imagine, highly sensitive, highly publicized, tried, fortunately, before a highly experienced district judge. This judge had granted a preliminary injunction, finding both vagueness and burdensomeness. Texas appealed. Texas legislature passes similar legislation. Plaintiffs again move to enjoin. District judge enters a preliminary injunction and sets a bench trial date. In preparation for the bench trial, the judge orders some discovery from the Texas Conference of Catholic Bishops. And the conference takes an interlocutory appeal from the discovery order. Those of you taking civil procedure in the law school know that rarely occurs and is even less frequently granted. Not here. The panel majority found that in ordering the discovery, the district court had abused its discretion in a number of ways, including violating the bishop's First Amendment rights. The opinion I want to focus on is the concurrence. In the concurring opinion, the second member of the panel majority wrote again and separately to agree with himself to reverse the district judge, and more importantly, to accuse, and that's not too strong a word, the district judge of compelling the discovery, quote, to retaliate against people of faith for not only believing in the sanctity of life, but also for wanting to do something about it. In other words, the district judge must have been motivated by animus, by personal prejudice against religion and against those who opposed abortions for religious reasons. That's a harsh accusation. The third and dissenting panel member did not let this go quietly. And I want to, and with apologies, quote extensively from this opinion. The dissent takes on the concurring judge's accusation of bias in the ruling after taking the majority to task for ignoring the limits on appellate court review and the usual rule against interlocutory review of discovery orders. The judge says as follows: even more troubling are the potshots directed at the district court. And the concurring opinion then piles on that the pecking order of the system allows appellate judges' views of the law to ultimately prevail should be satisfaction enough for us all. Amen. While vigorous disagreement about the law is part of the judicial function, there is no need to go beyond the identification of legal error by questioning the motives of our district court brethren. That is especially true when the legal issue is one that the majority opinion concedes is novel and when the ill motives are pure conjecture. What is one of the sins of the trial court according to the majority opinion? Working and issuing orders on a weekend. Guilty. Our district court colleagues deserve most of the credit for the federal judiciary being the shining light that it is, and he goes on to describe it. And unlike appellate judges on a divided panel who can trade barbs back and forth, a district judge has no opportunity to respond to personal attacks in an appellate opinion. He then goes on to praise the court, the district judge, saying he is now essentially working for free as a senior judge, volunteering to help to travel thousands of miles outside the district of his appointment to help with the heavy docket, speculating that malice is behind his decisions, seeking to expedite a high-profile case with a rapidly approaching trial date is not the award he is due. Okay, so district judges everywhere stand up and cheer. This guy is our hero. And it's an interesting contrast because he is looking beyond the specifics of the case. He's looking to institutional constraints. He's looking to the broader principles of the division of responsibilities and the limits and prerogatives that each of those critical roles of trial court and appellate court judges hold. And there are more examples that are similar, including some from some of my own cases, but I want to turn to the other side as well. Ambitious sides of judging can cover both sides of the political spectrum. In a Ninth Circuit case, in SmithKline Beecham Corp. Versus Abbott Labs, the Ninth Circuit, an appellate panel, held that the Equal Protection Clause forbids a party from striking a juror based on the juror's sexual orientation. The appellate court concluded that heightened scrutiny would, of course, apply to equal protection claims involving sexual orientation under the Supreme Court's decision in Windsor and based on history of discrimination that demonstrated the need for this heightened scrutiny. The lower court, according to the panel majority, erred in not applying the Batson framework, and Batson is the Supreme Court case that forbid racial discrimination in peremptory challenges of jurors on the ground that it discriminated against everyone, including members of the community who have a right to a broad spectrum of the community to be seated as jurors. And that the district court had erred in not applying the Batson framework to a peremptory strike that in the judgment of the appellate court was based on sexual orientation. The appellate court challenged the district court's finding, and I take this as an example of ambition triumphing over aspiration, without acknowledging that this area of the law was at the time very unsettled, may still be. And in the assumptions used to find a Batson violation on the record before the appellate court. During the voir dire, which is how we pronounce jury selection in Texas, none of this Frenchified stuff, voir dire. You can say it, voir dire. A venire member referred to his, quote, partner, and used the male pronoun in reference to the partner several times. The defense attorney did not ask questions about whether this potential juror could be fair and impartial if selected for the jury, but used a strike in the peremptory challenge against the juror. Plaintiff's counsel raised a Batson challenge, and the district judge rejected it for several reasons. First, the district judge acknowledged not knowing, not being confident of the answer to the question, does Batson apply here? And explained that she found it troubling to assume that there is a way to know who is gay and who isn't on the panel. And also noting that if the parties, this party, struck other individuals who might readily be identified in some way as gay, the ruling might change. But in the absence of that, there was no sufficient basis to find either on the law or on the facts in an area uniquely committed to the district court's on-the-ground decision-making, judgments of credibility, whether there was an improper exercise of a peremptory challenge or not. Ninth Circuit says no way. It goes right to the Batson challenge. It finds a prima facie case of discrimination that Batson clearly applies, and a failure by the striking lawyer to provide an adequate explanation of the exercise of the strike, result, Batson violation, new trial. Supreme Court's opinion in Windsor was not as clear in this application as the Ninth Circuit assumed, I don't think. And the appellate court at bottom not only makes that jump, but also disagrees with the district court's credibility findings, even though the venire members and the lawyers were before her, and she puts on the record her judgments about their credibility, ordinarily entitled to considerable deference. I would call the district judge's rulings aspirational in this very cautious approach to a novel legal question. And the acknowledgement, honest acknowledgement, I'm not sure what the right answer is here. I don't know. The judge was willing to state uncertainty on the record. Cases showing ambition often show the judges stating with complete confidence how to interpret the facts or read the law, even if many would find either or both propositions debatable. The judge here knew what the judge didn't know and had the honesty to say so. The appellate majority, utterly confident in its result. And I think the recognition of uncertainty, of indeterminacy, of limits on what you can know with confidence is a sign of aspiration in the judge. Judge Learned Hand, I think, said it most eloquently in a speech entitled, it's a one-page speech, The Spirit of Liberty. He gave this speech in 1944 during the war about what is perhaps our law's most fundamental aspiration, to achieve the spirit of liberty, freedom from oppression, freedom to be our aspirational selves. Learned Hand explains this spirit of liberty as, quote, the spirit which is not too sure that it is right. The spirit of ambition unalloyed by aspiration is either sure it is right or uncaring. Judge Hand's spirit of liberty is the spirit which seeks to understand the minds of other men and women. Aspiration seeks to do just this. Ambition without aspiration can often assume that it knows the minds of others or not be interested in doing so. So I don't want to end on a note of pessimism about the bench that I love. I'm going to conclude with a salute to another aspirational judge, also a former Hallows lecturer. In a ruling, this judge broke a 1-to-1 tie on a 3-judge panel. One of the panel members had ruled that the Affordable Care Act represented a valid exercise of the congressional power under the Commerce Clause in a pre-enforcement challenge. The other member of the panel reached the opposite conclusion. No matter where you stand on the Affordable Care Act as policy or law, this tie-breaking aspirational judge broke ranks with fellow conservative jurists with whom he had frequently been classified, and endorsed the constitutionality of the law against the facial pre-enforcement challenge. And his opinion is remarkable as a piece of judicial writing. It's legally cautious, it's politically deft, it defies pigeonholing on either side of the political spectrum. It focuses on coherent principles articulately stated of institutional integrity and soundness. And why is this a mark of aspiration instead of just good judging? Because when this judge wrote it, he was on every short list for a Republican president's Supreme Court nomination. And he deserved it by any measure. Highly respected, schooled in the classrooms of Justice Scalia and others self-defined as textualists. But when this judge voted to reject the constitutional challenge to the Affordable Care Act, I am confident he knew that he was either off or way down on the list as a result. This is judicial courage, a side of aspiration that we've seen before. We saw it with trial judges like Frank Johnson in Alabama, Elbert Tuttle, John Minor Wisdom, John R. Brown in the Fifth Circuit, who enforced desegregation rulings, knowing the personal cost to themselves, the shunning in their communities, even for some, the crosses burning in their front lawns. This judge, in a much more mundane setting of the constitutionality of a complicated statute that few had read from start to finish, similarly looked beyond the personal cost and was aspirational. So Justice Holmes lights this fire, and today, what do we do with it? What does this look like on the ground for the different roles we occupy? For the law student, good luck in your ambition. And I really mean that. I hope you get really good grades. I hope you all get A's. I hope you all get the journal positions, the moot court positions, the research assistant, whatever you want, internships, externships, fill in the blank, the offers. And I understand the law school does a wonderful job of placing its students in law careers, which not every law school can say. I commend your dean for that record. Many of these goals depend on external validation, and they can be so hard and time-consuming to achieve that they may seem enough. But they don't let you answer the Holmes questions. What do I aspire to in becoming a lawyer? And P.S., doing good deeds is just not enough of an answer. What am I learning to value that I didn't value before because of what I'm learning? What did I walk away with that I didn't have when I came, other than a degree? Now, pro bono work can be great, and for law students, it can allow the student to see some of the broader principles in a way that classroom alone doesn't do. But there can be more, and I want to give you an example. When I chaired the Civil Rules Committee, we held a hearing on proposed amendments to the rules, and they were controversial, although in hindsight, they were controversy over nothing. But one of the witnesses who appeared before us was a law student, and he was so excited, he could barely contain himself. He loved civil procedure. He loved the civil rules. Of course, I feel the same way, but there is therapy for this. And this is not the way that most law students or lawyers describe this part of the curriculum or the practice. But this student had come to see American civil procedure as a set of answers to a set of fundamental questions that every civil justice system has to answer. Who gets access to the court system? Pleading sufficiency, what's the test? Who gets what information that you don't have, that you need to pursue a claim or a defense? We call that discovery. Who gets the public resource of a judge, a jury, in a trial? Motions, summary judgments, trials. Who pays for all of this? It's the last part of the rule book. These are universal questions. They're permanent questions. The rules are one solution. There are lots of them. And this student had seen the universal behind all of those rules, 1 to 83. And it made the law come alive. He had a set of values in those connections that he had come to see. So my unsolicited advice, worth every penny you're paying for being here today, for the law student who aspires to aspiration, to push yourself to see what lies beyond the grades and the external validations. Take the doctrinal courses that will school you in the law's basic principles, the larger questions that you'll deal with when you practice the shopkeeper's arts. Don't just take a bunch of super specialized, esoteric electives that will push you out the door with a diploma and a crazy quilt of disassociated information. Learn our vocabulary. It's rich. It's wonderful. And learn the basic concepts that created them in the first place. Focus on learning the institutions of the enterprise of our legal system. This lets you learn what values you want to work to learn. And those, in Holmes's frame, the stuff of aspiration. They can add meaning to the products of ambition. And for the practicing lawyer, pretty much the same. All of this can be harder to achieve in the pressures of daily practice, but there are ways to aspire. One way is to develop skills, not hyper-specialized substantive knowledge, but skills. Skills are portable. Skills are internal. Skills are craft, and they connect you with the craftspeople who came before and who will follow. And it supports ambition, doesn't conflict with it at all. For the academic, I worry that ambition for publication, for promotion, accounts for some of the esoteric and hyper-specialized subject of much of legal scholarship today. I really worry about that. And I worry about something I think is related, which is the broad and sometimes seemingly reflexive academic hostility to justices and lower court judges based on which president of which political party appointed them. I worry that there is a temptation in the academy to take positions popular within the academy, provocative though they may be, outside the academy as a way of enhancing the likelihood of publication. I worry about the divide between the academy and the bench and the lack of help the academy and its scholarship provides the bench in its daily tasks, and the lack of support that goes both ways. The academy and the bench are natural allies. We need each other. We are united in having one aspiration. We have the duty to be right, to be fair, to be free of advocating for a client's preset interests. And with both the academy and the judiciary under what can feel like a siege, I urge that both aspire to better understand each other, be more modest in the certainty that each is right and the other is not, and speak to and with greater room for speaking on behalf of each other's concerns and fears. An aspiration for judges. Here, I've been a judge for 28 years, and I've loved every one of them. A judge who appears ambitious to the extent of excluding aspiration can, I fear, lend credibility to the perception of judges as political actors. And I worry about that greatly. Most of our cases, of course, have nothing political about them. And in the eyes of the outside world, they're really boring, but when you as a judge have to decide them and you have to be right, it's not boring. But there are cases that do intrude into vigorous and divisive public policy and political debates that can fuel this perception, no question. And reasonable minds can and certainly do legitimately disagree about a lot. But if an ambitious judge is one willing to reach a particular result or follow a particular approach, even if the record and the law don't support it, this can weaken the primary constraints on judges, the constraints of the record, the constraints of precedent, the constraints of institutional roles that keep us from reaching a result that we might personally prefer, but which just isn't supported enough. Judges without accountability based on these constraints can be unmoored, unchecked. They can be independent, but without accountability, I fear that can look like being political. And that's not independence. A judge, as viewed as a policy or political agent, is answering a question more like, what have you done for me lately? Instead of the question, what does the law require? What does the record require? And as some have recently reminded us, you can't have judicial independence, true judicial independence, without accountability, and you cannot have real accountability without independence. An accountable judiciary without independence is weak, enfeebled. An independent judiciary without accountability can be unmoored, in ways that fuel this perception. What checks the ambition of unmoored independence? Aspiration. The constraints that aspiration imposes. And when we are aspirational, and only then, do we deserve and are we likely to get and keep what Richard Arnold called the continuing consent of the governed. He was a wonderful Court of Appeals judge, nearly a Supreme Court justice, and he identified this consent as the keys to a judge's legitimacy, the judiciary's legitimacy, and therefore its independence. And when, as now, Congress fails to resolve recurring, foreseeable, and controversial issues, they will inevitably arise in the courts. It is ever more challenging to be and to be perceived as being aspirational. But even if Congress's reluctance to use its policymaking authority at least licenses and sometimes may require courts to resolve issues left unaddressed by democratically accountable policymakers, which is better, no question. That does not make the judicial decisions confronting those issues undemocratic, and it doesn't make the judges deciding the issues unaccountable. Not if the constraints of precedent, the facts, and concerns for institutional independence and roles is followed. So my best single lesson in aspirational judging didn't come from sitting on the bench with a robe. It came from my work on the rules committees. That group effort to wrestle with the large issues identified by my enthusiastic law student friend, to improve the quality of how a justice system answers the questions these large issues present, was among the most gratifying work I've ever done as a judge. And it can be and is done by lawyers, by academics, and even law students, all working together with judges. One reporter to the Civil Rules Committee and a great judge and law professor himself, Benjamin Kaplan, said it best, and with the honest acknowledgement of what could not be done. And I quote, "No one, I suppose, expects of a rule that it shall solve its problems fully and forever. Indeed, if the problems are real ones, they can never be solved. We are merely under the duty of trying continually to solve them." Working to meet that duty was for me the stuff of aspiration. So for judges, for academics, for lawyers and law students, I think that Holmes generally got it right. Look for the larger themes, the larger questions, the acquisition of skills and competence to understand them, to give meaning to the specific problems you're asked to resolve. And at the end of the day, aspiration and ambition may meet. I think they did for Justice Holmes. And for me, I'm ambitious after 28 years, and I aspire to work on interesting and important issues with people who I respect and admire. And I admire them because of how and what they aspire to be and do. Being here, working with Dean Kearney, fits that bill. And I thank you, Dean. And I thank all of you for the chance to think about why I love my work, my ambition, and my aspiration, and to hope that you also love what you have chosen to spend your lives doing, and that you bring aspiration to all you are ambitious to do, and that you bring ambition to all that you aspire to do. Thank you. enough time right now.
So we're going to have a reception in the forum, and I know that Judge Rosenthal is eager to engage with any and all of you who have questions or simply wish to press points upon her. She did this most gladly with our judicial interns over the noon hour, and Professor Hammer, who leads that program, was rhapsodic. I don't know that that adjective has ever been applied to Tom Hammer before about it. So thank you to Chief Judge Lee Rosenthal. Thank you to all of you for being here. Truly something very much worth meditating upon. We're very grateful. So let's meet in the Zilber Forum.